the second husband of mine refused to take care of the children. So I had to leave, my lord, and go back to my father and my brother. Father, my lord, has not paid any maintenance at all.
It was 13 years ago. She is the daughter of a High Court judge. And from day one till today, you are harassing me. Everywhere they have blamed me. They inflicted on me this inferiority complex. I am the High Court judge's daughter. I can send you to jail. She went to the extent of beating my old 80-year-old mother.
You are a father, you must take care of the children. That's the least you can do. Lady is not working. She does not have the ability to work. Here for the petition and the connected matter. And this is only for maintenance for the children. The father, my lord, has not paid any maintenance at all. Come to para
Both
9.
of them are again married.
Both of them got married again, but the second husband of mine refused to take care of the children. So I had to leave, my lord, and go back to my father and my brother. So my father and brother have been taking care of me and my children. And have paid their school fees. Every single expense of theirs has been met by the father, and the father, my lord, is a retired person.
How much is awarded?
3,000 rupees a month. It is an admitted fact that first daughter has completed her BE education and distinction, and now she's working. That's now. Petitioner taking contention. Now the first daughter is working and getting salary. There's no necessity to pay the maintenance amount.
So why
Admitted,
are you seeking maintenance for this earning daughter?
not for earning daughter. It was
The other
still.
one.
It was still no. It has been pending for a long time.
When was it filed?
Not the 2013,
And order came to be passed on?
24, 23, 11 December 23. And therefore, my lord,
Intermaintenance was granted in between.
and my lord, therefore, we have given all the records of all the payments made towards educational expenses.
So when this daughter has completed her BE?
B, my lord, when she turned, I think I'll just give you lordships that date. But the court, anyway, my lord, that may or may not arise because the manner in which the court has calculated the compensation is on some kind of an assumption that there is an order in the High Court saying you have to pay that much, and therefore that's all that has to be paid. And let me just quickly take your lordships. It's only 2-3 paragraphs where there's absolute non-consideration, I would say. Admittedly, my lord, in page 19, third line, admittedly, maintenance amount is claimed by children prior to attaining the majority. When they were studying and required the amount, at that time they've claimed the maintenance amount. Without waiting for payment by the father, mother of the children, by taking assistance from a father and brother, completed the education of children. Now the petitioner cannot avoid his responsibility taking such a contention. Both children are studying at standard school, completed the education with hard work, and the result is also distinction. Admittedly, petitioner had paid interim maintenance of 3,000 each to the children as per order of Hon'ble High Court. There's no order of any court, my lord. According to petitioner, after deducting that amount comes to 1,89,000. He has calculated arrears which comes to 4,65,000 and has already paid 1,44,000 before the Hon'ble High Court. Arrears is only 3,21,000 and he is ready to pay the amount. It is a liability of petitioner to pay the school fee of the children. IN number 11. Respondent claimed 1,98,000 school fee of children which was taken by her from a father and brother. That was for 1 year.
Which order of the High Court they are referring to?
There's no order. I don't know which order it is. There's no reference of any order. There's no direction to pay 3,000 rupees maintenance. And nothing is placed before the court. And on that basis, my lord, for 1 year in IN number 11, we said you have to pay immediately the school fee, which he did not pay. That was 1,98,000. So the court says that is to be paid. But I have led evidence to show the entire calculations over the years of how much school fee has been paid. And there's no dispute on the amounts at all. Not a single dispute raised, not with respect to the amount spent by us.
Marriage expenses at 8 lakhs each to the children.
8 lakhs to the children. 1,98,000 is for 1 year school fee, 1 year's school fee. And 3,21,000 was arrears of maintenance. But the whole direction was that the court must consider what the maintenance amount is and make a determination. There's absolutely no consideration, and all the material, my lord, has been completely ignored.
We'll ask.
Very well.
Yes.
May it please you, Lord. My lord, your lordship may come to my writ petition 7838.
No, before you proceed,
Yes.
High Court in which case has directed to pay 3,000? Where is the order?
Order is dated 18/10/2016, my lord.
18/10/2000.
18/10/2016.
Is it filed?
It was it is not filed here. In another criminal case, it was ordered. In another criminal case, it was ordered.
You have a copy of it?
Today I don't have. I'll produce it. I have a copy. Today I don't have the copy.
The criminal case?
I thought they would not engage me on this or this court. I will produce this order of the court. It was a considered order and the other party was also present. 3,000 each was given to the child. It was 13 years ago. At that time, that 3,000 was very good amount. Now it may not be good amount, but I have paid up to the age of their attaining majority. I have paid up to date. 6,000 for 2 children. This is one aspect of the matter.
Then what about the school fees and other things?
School fees is, my lord, maintenance is not defined anywhere in any book. I have been making a research on this. Maintenance is not defined in any act, Family Court Act, Hindu Marriage Act, Maintenance Act, nothing. It is by the rule, by procedure, by precedents, by judge-made laws. We have come to understand that maintenance is food, tuition fees, medical fees, their transportation. Therefore, the second order passed by the learned trial court judge asking me to pay school fees is a part of maintenance.
No, before that.
Therefore, my submission is there cannot be a maintenance for transportation, maintenance for food, maintenance for fees. That's my submission. My submission is 3,000 plus 3,000 for 2 children
No,
or
1 minute.
inclusive of all this.
In a criminal proceedings, that order is passed when? Which year?
18/10/2016.
18/10?
2016, 16.
This petition is filed?
This
No,
petition
that
is filed
not
in
that
13.
criminal proceedings is not something about a maintenance. No, when the petition is filed before the court, when the evidence is let in, court has to independently decide it, how much is the maintenance
Yes.
you are entitled.
Yes.
And after determining the maintenance,
Yes, ma'am.
then this much of amount the father is already paying,
Yes,
deduct it, and then fix the maintenance.
yes.
But that is not done by the court.
No, my lord, it is not challenged. You are very much there for the past 10 years fighting the case in the court and you did not challenge this 3,000. 3,000 was agreed, was ordered and I paid 1,40,000 on that date I paid.
Unfortunately.
And there was no objection. You did not
Sorry.
file an application for modification.
No.
You did not file an application for 10 years.
Without an order copy being on record either before the court below
I'll produce.
or
for-
before this court.
Yes, ma'am.
Now we are talking about something of 6,000 and but unfortunately court below cannot say High Court has asked in granted 6,000. So I will also do.
My lord,
This is an application.
it's not like that.
Application.
It's not like that. I'm sorry, my lord. It's not like that. It was adjudicated. It was consented. Parties were present. It's not an ex parte order. We were present. And from 16 onwards till today, 2024, you have not raised your little finger saying that it is more or less. You should have applied for a modification, applied for enhancement. That is not there. Then is what is called as acquiescence. You have accepted and I have paid and you have accepted also. Therefore, you cannot now go back and say, this after 10 years in 2024,
Have you
when the
seen
girls
that
are drawing 1,50,000 salary. No, please sit down. I did not
Sit down,
interrupt
sir.
you.
I will take instructions from the
No,
court.
please
not
sit
from
down.
you.
Please sit down.
Tell me to
My
sit down.
lord, this you have raised when the 2 children have become majors 4 years ago, when the 2 children are earning 1,50,000 per month, and they don't have courtesy to tell me that they are doing this.
No, this IA
Your
is
lordship
filed-
may kindly take.
IA is filed in 2013.
Yes, no, my lord, petition is filed. IA is filed in 16.
No.
From the date of filing the
When is
application.
IA filed for interim maintenance?
Interim, my lord, this maintenance has practically become the final maintenance today. Though it was initially an application, it has become final
No,
maintenance.
whenever it is.
Yes.
When is it filed?
My lord, the application was filed on 27/3/2013.
27/3/13.
2013
You are right.
and 14/6/2013. That IA number 10 is filed on 27/3/2013 IA number 11 is filed.
Finally, the court has passed a final order in the petition
Finally,
itself.
in
No,
the
it's on IA.
1 minute.
IA 10 and IA 11.
Lord, I think I should explain this. Please see the page 111 of my petition. This order dated 18/10/2016 is here. This is the order.
Which page?
Page 111.
Yes.
This is dated, no lordship will see on the top,
Mm.
18/10/2016. Page 111.
Oh, this is the one they're referring.
This is the order. Now, your lordship may kindly see this order.
18th October
2016.
2016. And this is
This is
arising out of?
in the GNWC case which they had filed for custody of the children.
Hmm.
We had filed an application for maintenance. Then, Lord, when the applications were being heard, they withdrew the petition. The question was, should these IAs be considered notwithstanding the so-called withdrawal? That was being considered. Your lordship may kindly see the order, para 6, at page 115. That apart, it is no doubt true that the main petition is filed by the respondent herein seeking that the respondent be appointed as the guardian of the minor children. That is my learned friend's clients. It is in such proceedings by invoking the inherent power of the court, an application is filed with the petitioner herein with whom the children are residing, seeking for appropriate orders for payment of school fee. In fact, that was one of the aspects which should have required consideration by the court below, since when the petition seeks appointment to the respondent as guardian of the minor children, whether the respondent is interested in taking care of the welfare of the children is also one of the aspects which should have weighed in the mind of the court below. And if such consideration was to be made, certainly the court below ought to have taken note of the contention and merits to come to a conclusion as to whether the respondent is capable of taking care of children. And in that light, whether the respondent is to be directed to either pay the maintenance or the school fee by taking into consideration merits of the contention and expenses as claimed by taking note as to whether such amount has been expended on the children and to what extent the respondent should be held responsible for maintaining children in the context. And that is how these IA 10 and 11 were directed to be considered. From that date till 2024, my lord, these applications have been pending. And now it is considered saying simply on a statement made that 3,000 rupees was paid by me and therefore that is the amount of maintenance and therefore nothing more has to be paid. We must not look at any of this voluminous evidence that we have placed before the court pointing out as to what is the exact expense. We are not asking for profit, not here. It is not a profit. You are a father, you must take care of the children. That's the least you can do. Educational expenses, food. Is this lady is not working? She does not have the ability to work. Now she is at least ensured, my lord, with the help of a father and a brother, children have been given an education. Otherwise, the children would have been on the streets today. And today the father is saying, I'll pay 3,000 rupees, that is maintenance.
Yes, my lord. In 2013, 14, 15, 3,000 was a good money for me. I am not a businessman. I am only a software engineer. Your lordship may kindly permit me to say a few background of this. My learned friend has not stated any background. My lord, she is the daughter of a High Court judge. He is the daughter of a tailor. Because he was a BE graduate, handsome, simple man, honest man, you married your daughter with him. And from day one till today, you are harassing me. A small instance, I may bring it at the request of this Hon'ble Court. There are many instances where I have been abused, humiliated, and thrown out. One small instance you may permit me to submit. When Mr. Mujib was here, a registrar of this Hon'ble Court, he arranged this marriage. And when there was difference of opinion between the husband and wife, he tried for a compromise. A compromise meeting was arranged in a mosque. Justice, the father of the lady, comes with his official car with red light and 2 jeeps, police jeeps. No, please, don't disturb me. I have the facts. After all,
The claim of maintenance is not about the father. I'm sorry.
It's based on the facts.
Can't keep making
I am
statements
taking
like-
permission of this Hon'ble Court, bring you to your kind notice, how he treated me, how the wife also is responsible for this tragedy.
Whatever it is, that would be considered in a case where.
She is a BSc graduate, she is healthy, she must have taken an appointment and looked after her children also. And you have I would now your honor doesn't want to permit me to say that, give this information or incident, I would request my lord to see page number 64 of my book. Would
Yes.
you even now, would you direct me to pay the maintenance, my lord?
Yes.
Please read this. My lord, they didn't want the father and the children to be met. There are incidents which my learned will object and your lordship may also not permit me. I'll just read this, my lord. This is an application filed by the lady, the wife. What they say is, this Hon'ble Court may be pleased to pass an order prohibiting the opponent petitioner, me, husband, entering and visiting their children's, that is, Moina Yufra and Hajira, present school, namely Holy Angels High School number 2, 5th Main Road, 4th Cross, RPC Layout, MP Nagar, and their any future schools, colleges, hostel of their future studies, and visiting at their residence, and from attempting to communicate in any forum whatsoever with these aggrieved children, Moina Irfan so and so, including personal, oral, written, electronic or telegraphic contact,
Yes.
in the interest of the protection and promotion of their welfare and healthy development and in the ends of justice. Fine words, but butters no parents' lips. These are the words used by them. What is the law about this? I wanted to bring it to your lordship's kind concern. The law is, once the daughters do not want to engage themselves with the father, do not want to maintain relationship with them, they cannot claim the maintenance. I would submit 3 judgments to that. They are disentitled.
Is it so? They
Now
never
they
had a
filed
contact
today,
with the
day after
father?
yesterday, day before yesterday.
There's a report of of my lord, a counsellor who was appointed in 2014 to ensure that the children meet the father. And I have stated the report in my objection statement as to what was said and what happened.
Take the judgment.
These 3
Where did you say
judgments.
so?
My lord, in our objection statement, we extracted that
Page number?
page in the objection statement, my lord, the third page. We have extracted that report in the objection statement, my lord, to his writ petition. In 7838, 7838.
Yes.
Yes, in that, my lord, the page number 3.
6.
I beg your pardon, page number 3 of the statement of objections. In the objection statement itself, we've extracted that report. Your report copy. No?
Yes. Where is that?
That we've extracted the entire report here itself because I'm told, my lord, the copy was very blurred. My report in
in
compliance.
compliance with the Hon'ble Court's order.
Yes, yes. Or and communication made to me. Both children, so and so of the petitioner Azimullah Khan, were brought to mediation center by maternal uncle. One Ul Haq, because not mothers there, they said anything will happen. Children's mother had not come to the mediation center, accompanying the children. Petitioner present at the mediation center at 3:30 and said children's uncle left the children free to meet and converse with the petitioner, father in the mediation center room, by keeping himself away from the mediation center. Petitioner started talking to them, but the children remained silent. I found them in a scared mood without responding to the gestures of the petitioner father. After a little while, both children went away from the petitioner father and joined their uncle, who was sitting far away from them. Then I made them come back to the petitioner father sitting near him. I told and wanted them to be talking to the petitioner. Curiously, both children started spontaneously weeping and crying and did not talk to the petitioner. After some time, in a sad and scared condition, children again quietly went away to the uncle.
Yes, I've seen that.
And my lord, I must point out to you what happened. One night, the mother and the 2 children were thrown out into the streets by the father and his mother. And my lord, on the street, they were in the middle of the night. They were on the street, and thereafter, my lord, all of this problem happened. So to make allegations and in the petition, my lord, if your lordship see the kind of allegations made against his former father-in-law, he accused him of murder of his own son.
Where is the document? Where is the evidence? These are all right. This
Please see, my lord, if my learned friend
the
is
father of
saying-
the wife for every.
No. I
application.
think we are expanding the scope of the petition itself.
Correct.
Please come to the judgments. Which one you're relying on?
Now, my lord,
Two points of judgment.
now that he has submitted about the mediation visitation rights,
Hmm.
they did not honor the orders of the Hon'ble Court.
Hmm.
They did not encourage me to meet my children
Hmm.
because children were brainwashed.
Yes.
The children were told that the father is a devil, father is a murderer. Therefore, the fact that I went to the director in the family court, requested him to appoint a mediator to supervise the visitation rights. I will just read a letter that mediator who was appointed to supervise the visitation rights has written a letter to the director. I have not.
That's what
produced
is
it.
extracted, that I.
No, 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 this is a letter by mediator who was appointed to supervise the visiting rights. 2 minutes, one second.